Right-to-work advocates are hailing a Supreme Court ruling which overturns a California law allowing union agents that is, to occupy farmers' land to unionize workers. Here's One America's John Hines.
Mark Mix, as president of the National Right to Work Foundation, you are lauding a new Supreme Court ruling that favors your right to work agenda, saying that a California law forcing farmers to let union agents occupy their property for solicitation to workers violates private property rights. Why do you seem to think that this is an important Supreme Court decision which may favor right to work laws?
Well, the connection is more important to the idea of privilege for union officials. I mean, this 45-year-old Agricultural Labor Relations Board rule that was put in place in California, specifically designed to give union organizers access to private property in order to organize workers, is really something of an anomaly. I mean, this is an interesting case where union officials were granted the opportunity to visit a property to organize workers for 3 hours a day for 120 days a year, John. I mean, this is really an amazing story because any union could have exercised this opportunity. They go to the Agricultural Labor Relations Board. So in theory, you could have 4 unions going to your property 3 hours a day, 120 days a year. And basically, this is a private organization trying to organize workers. And the Supreme Court actually looked at this and found that it was a per se taking under the Fifth Amendment.
Presumably this was, in this situation, apparently it was union organizers who were given access to the property so they could unionize or organize workers. Is that essentially what was going on?
Yeah, that's right. I mean, this was not about a union that was representing workers that was going there to talk to them. This was the opportunity for union organizers to get on properties to organize unionization. And, you know, the test really under the National Labor Relations Act is whether or not there's other means to contact these workers. And certainly today, John, with the internet and all the things, the stimulus that we get, you know, moment by moment, there's lots of other means for union organizers to talk to these workers.
But this does tend to help the right to work cause, does it not? I mean, at the margins, it seems to bolster the right to work policies in the country, and it is consistent with the right to work, I guess, agenda perhaps of conservatives. Is that correct?
Well, I would say that definitely, John, and I would describe that in the sense that union officials have been granted these special privileges. First and foremost, the privilege to force you into their collective and represent you without their consent. I mean, that's one of the privileges granted back in 1935, upheld in 1937. And you start listing these privileges, and one of them was this Agricultural Labor Relations Board that said a private organization could invade private property to basically conduct their business. And so when we start rolling back the privileges of organized labor, and not necessarily their rights, because workers can organize. There's nothing in the law that stops workers from saying, we want to be in unions, and they can do that. There's a process for it.
They can't just be forced to pay the dues to keep a job.
Yeah. Well, that's right. They can organize if they want to, and there's protections for union organizing. But the idea that these privileges are granted to a private organization, I think that's the takeaway in our view, is that union officials, people are starting to recognize that these special privileges don't belong in the hands of private organizations like labor unions. If they want to organize workers, go ahead and do it, but don't use governmental power to do it. That's the bottom line.
So no special privileges for organized labor or organizing labor practices, apparently. That's what this is. That's kind of the net here, I guess, right?
I think that's right. I think that's the takeaway for us. Certainly from a private property standpoint, the idea that the Supreme Court upholds, again, you know, the Fifth Amendment takings amendment is important to private property owners. And so that idea of accessing property is one thing, but giving a private organization access to property is entirely different.
National Right to Work Foundation President Mark Mix talking about the Supreme Court decision Cedar Point, which prevents union organizers from using private property, the property of the owners of the companies and businesses, to organize union membership. Thank you very much for joining us on One American News, sir.
My privilege. Thank you, John.